So, along with Vardarajan's case, it will only be pertinent to discuss the classic case of R versus Prince, which was very famous for many reasons, but it involved a person called Prince, who was charged with the kidnapping of a 14-year-old girl called Annie Phillips. Now, the biggest and the most controversial element in this case was Annie Phillips, as the court has also accepted, never really looked like she was 14 years old. She looked like an individual who was way beyond 16 years of age, and the most interesting turning point of the case was Prince decided to take her out when Annie Phillips misrepresented before him that she was actually 18 years old. Now, when we look at the factual matrix of this case, 2 points have to be noted. One, Annie Phillips, as has been accepted in the court, doesn't look anywhere to be close to 14 years of age. She looks to be much older than 16 years of age, and secondly, that she has misrepresented her age as 18 before Prince, following which he has taken Annie Phillips. Now, the case revolved around the tripod of taking, consent and reasonable mistake of fact. So, the question here was, can you hold Prince responsible for the commission of the offence under the specific legislation? The problem with Prince's case was Prince did commit a reasonable mistake of fact, and that was accepted by most of the judges in the court. In this background, it was necessary for us to focus on the mens rea of the concerned individual, and the debate was whether we can actually hold Prince responsible for committing the said offence, especially when Annie Phillips misrepresents before him as saying that it's actually something where she qualifies as an 18-year-old and Prince mistakes her to be an 18-year-old individual. Now, the court was divided in its opinion, and the dissenting opinion was equally forcible, was equally kind of acceptable to many. So, while the majority held Prince responsible for the commission of the offence, the question was whether he should be held responsible or not, and the dissenting opinion in this case is noteworthy. Here, the judges who dissented with the idea that he should not be held guilty, their opinion was primarily based on one question: whether Prince can be convicted because he really did not have a mens rea to commit the offence. So, if mens rea is absent in a given case, can you hold a person responsible for the commission of the offence? Now, it is at this juncture that the liaisoning between taking, consent, the diametrics which develop here between reasonable mistake of fact have to be taken into consideration. So, although the dissenting opinion was that the mistake was a reasonable one, and therefore, Prince should not be guilty of committing the offence, it was also noted that the offence that he was charged with was one of strict liability, and therefore, mens rea did not really have a purpose, but it does send across a very important question: without mens rea, can we really hold a person responsible for the commission of an offence? So, with this, let us just move to the next important ingredient of kidnapping, which is out of the keeping of lawful guardian. So, what does the term essentially mean is the question. When we say lawful guardian, we refer to somebody who has been charged with the care and protection of the minor, and when the care and protection of the minor as well as the custody of the minor is with the lawful guardian, a person is said to have taken the minor out of the keeping of the lawful guardian if he or she has taken such person out of the control of the person when the minor was had been placed in control of such guardian. Moving on, we need to then figure out an analogous offence and the ingredients of that offence under section 362. Kidnapping is often read together with abduction. Section 362 defines abduction and points out that there are two essential elements, namely compelling an individual by force or inducing by any deceitful means, and thereby causing such person to go from any place. So, the offence of abduction is complete the minute you compel the person to move from one place to another place. Abduction is not an offence per se, but it becomes punishable when it is done with an intention to commit another offence. Abduction is an offence if it is done with the intention to commit murder, wrongful restraint or wrongful confinement, so on and so forth. So, the term deceitful here suggests that the means and methods by which a person has been caused to go are actually means which have been acquired by a process of misrepresentation. Now, there are very significant differences between kidnapping and abduction. In kidnapping, the offence is committed against a minor only, but abduction can be committed against anybody. So, whether the person is a major, an adult or a minor does not really make a difference. Secondly, a minor's consent is not relevant for exonerating the accused from liability for kidnapping. Now, in case of abduction, however, the victim's consent will negate liability. Thirdly, kidnapping is committed when a person is taken out of the keeping of a lawful guardian. However, for the offence of abduction to be committed, any person may be moved from one place to another by use of deceitful means or by use of misrepresentation or by the use of force, and only then the offence of abduction will be said to have been committed. So, as we already discussed, abduction is read together with other offences and becomes an offence only when we combine abduction with other offences like murder, wrongful restraint, etc. So, section 363A talks about kidnapping or maiming a minor for the purpose of begging. That is again another form of kidnapping, and also abduction when you send the person out of one place to another. Section 364 makes an abduction or kidnapping for the purpose of committing murder a punishable offence. Section 364 penalizes kidnapping for the purpose of ransom with death or imprisonment and fine. Section 365 prescribes punishment for up to 7 years for the offence of kidnapping or abduction. Section 366 deals with the offence of kidnapping, abducting or inducing a woman to compel her marriage and prescribes an imprisonment for a duration of 10 years and fine. The imprisonment may be of either description, may be rigorous or may be simple for that matter. Section 366A prescribes punishment for procuring a girl below 18 years of age with the knowledge that she will be either forced or seduced to illicit intercourse. Section 366B penalizes import of a girl from a foreign country with imprisonment extending up to 10 years and fine. Section 367 makes it an offence to kidnap or abduct a person with the object of subjecting him or her to grievous hurt, slavery, etc. Section 368 penalizes a person who wrongfully confines or conceals a person who has been already kidnapped or abducted. Section 369 penalizes kidnapping or abducting a child below 10 years of age with the purpose of taking some movable property from the person. Section 370 to 374 penalize buying or disposing of any person as slave, habitual dealing in slaves, etc. So, as to summarize what we just covered, it is important for us to take note of a few points that we have already discussed. First and foremost, kidnapping under the Indian Penal Code is of two types: kidnapping from India and kidnapping from lawful guardianship. The definition of kidnapping from India has been provided under section 360, whereas section 361 defines kidnapping from lawful guardianship. Thirdly, there is a difference between taking and enticing. While taking signifies that a person has been escorted or has been caused to go, enticing means that a minor was caused to go or a person was caused to go by showing a temptation of some sort. This significant difference between taking and enticing has always to be kept in mind when we discuss the elements of kidnapping. When we entice somebody, we always show a temptation. So, for instance, A can be said to be taken by B if A just escorts A. So, if the minor is just escorted by the offender, that would amount to a situation of taking. But suppose the offender gives a chocolate to the minor and asks the minor to follow him, and the minor follows him because the temptation was sufficient to cause the minor to move, then that would amount to a situation of enticing. The case of Varadarajan versus State of Madras is a very important case which we have also discussed at length in a very detailed manner, and it is a landmark case and discusses in an in-depth way what constitutes or connotes the term taking. In the case of R versus Prince, the relevance of intention and the value of minor's consent was discussed. Section 362 defines abduction and states that elements of deceit, inducement, force and moving a person away from the place are necessary to establish the offence. There are vital differences between kidnapping and abduction, which we have already discussed, and sections 363A to 369 deal with aggravated forms of kidnapping or abduction. Sections 370 to 373 deal with slavery and forced labor. So, as to conclude, the 5th Law Commission has in its 42nd report suggested various amendments to the definitions of kidnapping and abduction to meet its ultimate purpose of protecting the interest of minor and protecting minors from being kidnapped or from being abducted or from being transported from the territory of India into a foreign territory. That would be all. Thank you.